It is time for us to check in with our CJD legal contributor. That is Chris Dimakos. And Chris, a couple of really good stories in the news this week, but I want to start the one that I think has most people a little baffled. And that's a story of an art teacher who, on his own, decided to take the work produced by his students in class, put them on the internet on his own website, and sell them without their permission. Now, it was such a bizarre story. It's a couple of days later, we find out just today that parents involved here are now suing the school board, I guess, and this is the Lester B. Pearson board, for $350,000. Now, I should point out the artwork here, not just being sold, but it's being sold on mugs and T-shirts, whatever else. This is not exactly Picasso. This is stuff produced in class by kids, in an art class by their teachers. So first of all, with respect to copyright, does it matter if it's a significant work or not, or just the fact that you've taken this without their permission and are trying to sell it for your own profit? Is that all that's necessary here?
That's exactly it. That's all that's necessary. So we have here a situation where the works were produced in school for the purposes of learning, purposes of teaching in class, and there's no, to my understanding, and I don't believe the parents have admitted to so, that there's any consent for them to use that in any other place. So that being said, and the lawsuit here, and the reason you mentioned the school board, and we've talked about this many times, where you talk about the relationship between the parents and that art teacher, it's the employer of that art teacher that they have a legal beef with. I mean, obviously they're not happy with what happened, but they're now saying that the school board, the employer, is liable. And in order for them to be successful, because we have here an employee who's not doing something during school hours, they're doing it away from school. But if you can prove that there's a link between what they're doing away from school and the employment and the position that they hold, if you can have that causal link, well, then you'll be successful in court. So in this case, I don't think it's going to be an issue for them. It's an art teacher. She or he got the works while the kids were in class. And, the only reason they had possession of those works is because they're a teacher. So I think the causal link is there. The only question now is going to be how much and what the school board is willing to do to try and settle this thing before it continues to escalate and go through the formal judicial process.
Yeah, I think one of the things I heard one of the parents suggesting, they're partly upset not only that this happened, that the teacher basically did this, but the fact that the school has really not done anything other than say, oh yeah, we're aware of it and we're looking into it.
Yeah, and many times when you have school boards, they are set up in a way to deal with problems that arise on a daily basis, right? So you have issues at school, you have issues between students, you have teachers who might not get along with one of the students. There's issues that they've been equipped for. This is not something that's in their wheelhouse that
Right.
they deal with every single day. So whenever you have these types of situations, and it can be anything, right? It can even be an employer with an employee who does something apart. If they're not equipped for it, then the first answer is always, we're going to take a look at this. And what that really means is we're going to go and get some help here and have us figure out what we should do in these cases, because we have not had it happen before. So what the school is basically saying, and they don't want to say it like this, is, hey, we have no idea how to handle this. We're going to get some advice from some professionals, and then we'll get back to you when we know what the direction we're going to take is.
So let me ask one more question in this. So we're talking about the school board as the organization being sued here. What if you're this individual, this art teacher, and I know you're employed by the school board, but can you individually be sued civilly over what you've done here because you violated copyright?
You can be sued individually, and what the defense, one of the main defenses people set up is say, hey, I was doing this through my job. You should be suing the employer, not myself. And that's a very common defense. But can you get sued? Absolutely. In fact, it's probably prudent to add as many people as possible on that suit, right. And then later on, if you have to amend your proceedings, you'll do it. But you can. But a defense is going to be, hey, I'm exercising my job here. I was doing so as an art teacher. Did I make a mistake? Yes. But that doesn't mean that, I did something on my own. This is something that I did because I thought it was good, or whatever it is, whatever the excuse is. But there's a dynamic there, just like we talked about, tenant versus tenant. If one tenant has a problem with another tenant, they go to the landlord. If one employee has a problem with another employee at the workplace, they go to the employer. That's who governs the relationship. And in this case, it's the school board that governs this relationship.
Okay. Let me move on to another story that kind of came out of the blue. I read this in La Presse this week. So here's the story of a Montreal woman who fell on a sidewalk. So this is in the winter. We've heard these stories. Typically what happens You have a claim against the city, you file against the city. But in this particular case, and I imagine that because of this, this kind of sets a precedent. This woman was heading for her car when she fell on an icy sidewalk, for example. And it turns out now that I guess a judge has decided that it's not the city who should be liable, but the SAAQ that should be liable, because it's considered as soon as your car came into the equation that it's a road accident. And if you imagine just down the list of any time this would have happened to somebody, you could have touched your car and had an accident, and that would now have to be considered under the SAAQ and not under the municipal government. So this seems a pretty significant change.
It is, and what's happening here is there's a definition as to what constitutes a motor vehicle accident, and we've seen that definition, the scope of that definition, widen over the years and include more and more accidents. We talked about someone who was sitting in a parked car and a tree falls on the vehicle and they get hurt. That was considered a vehicle accident. So we're starting to see more and more the scope and get wider and wider. And in this case, they didn't even touch the car. You said those words. If you just touch your car, well, in this case, she didn't even get to the car. She had a package that she wanted to put in her trunk,
right.
And as she's walking with the package, not even touching the car, she slips and falls. But what the courts did was say, the minute that there is a car involved in this equation, and you use those words, and that's exactly the words that the judge used. The minute you have a car that's involved in the equation, even if you don't make any contact with your car, if it's a car that is involved in this equation, well, then it's more likely than not that it's going to be deemed a motor vehicle accident, and you get compensated through this no-fault regime we have in Quebec, which is why we pay a lot more for our registration than other provinces do. But what you talked about, this scope and the precedent that it sets is, well, now someone's riding their bike, and they swerve out of the way because they see a car. They don't touch the car, they don't hit the car, but because they swerve out of the way for a car that made maybe a jerked the wheel, or they made a wrong turn, and they get hurt on their bike, well, that also would constitute a motor vehicle accident, even though they never touched a car and they were on a bike. So we're seeing this scope get wider and wider and wider. And one of the reasons, the pragmatic reasons, is this is a government body that has millions and millions of dollars of surplus every year. They have, I think, only maybe 30 or 40% of the money that they make goes to actual motorists and injuries. The rest is spread out to the government. So I think it's in the court's interest to try and enlarge the scope of this, because again, there is heavy surpluses in this institution, and why not help some people
Sure.
out when it comes to getting injured?
Although I will point out, because this is the part that really surprised me, the downside is if you'd have sued the city, you might have sued for, I think she wanted in this particular case, she was going to sue for $15,000. Now that the SAAQ is involved, even if she wins her case, it would be apparently for far less money, because the payouts from them are much less than you would get from a municipal government.
Absolutely, and that's a case that's been battled many times. We've had drivers that have been hit by drunk drivers in other provinces, and if they sue the driver themselves through insurance companies, they would get millions. But if you go through the SAC, you would get maybe $100,000. So this has happened on many occasions where people have tried to exclude themselves from the SAC regime because they want to be able to get
Right.
more. But then again, if you're somebody who suffers a hit and run and you can't locate anybody, or you get hit by a drunk driver and they have nothing to their name and they have no insurance, in those cases you would
Right.
get compensated where otherwise you wouldn't. So there's a
All right.
trade-off there.
There sure is. Chris, thank you so much. Appreciate it.
Thanks, Aaron.